Hold on a second. Gotta make sure we get all technically available here. How are we looking over there, Techno Guru? Okay, all right, we're good to go. So, Chairman, if you want to call us to order, we'll get after it.
Very well. This meeting is called on February 20th, 2025. It's a meeting of the Board of Examiners for Land Surveyors, and it has been noticed on the website since December the 18th, 2024. And this month's agenda was posted on February 13th, 2025.
All right. We'll do a roll call then. We got Jay Kaufman.
Here.
Gary Clark.
Here.
Kevin Martin.
Here.
And Justin Raines.
Here.
All right. We have quorum. The notice of the public comment period, that's located at the end of the agenda. Just want to let those folks know that may be present or online joining us today that right after new business, right before we adjourn, we'll have an opportunity for them to address the board at that time. So we'll ask you to sign in. And, of course, if you haven't already, if there's someone present and they need to sign in here or online, they can sign in on the chat, and we'll give you that opportunity. All right, looks like we're ready for the agenda then.
All right. Excuse me. All right. We all have the agenda in front of you. Is there any changes, or we have a motion to adopt the agenda as is?
Motion to adopt.
Second.
All in favor say aye.
Aye.
And then we have you, in your package, you should have the meeting minutes from November 22nd. Has everyone had the opportunity to look over those, and are there any changes or additions that needs to be made?
Move to approve.
Second.
In favor, say aye.
Aye.
Very well. So then and with that, we move to the professional society report. Do we have?
Let's see if we have anyone online. Do we have it? Okay, it looks like Mr. Cleveland is online. Mr. Cleveland, you're free to go.
Good morning, everybody. I hope everybody's doing well. I appreciate the opportunity to attend virtually. It's always a great convenience, and we definitely appreciate that. I apologize for coughing. I'm getting over the flu. TAPS is getting ready for our annual conference, March 6th through the 8th. Just kind of getting the final things ready for that. Speakers, of course, lined up and everything. Just getting all the final things geared up for that. And that's really kind of been our main focus the last 4 or 5 months, is just getting ready for the upcoming conference, and excited to see everybody, and looking forward to some really great continuing education seminars. Other than that, not a whole lot going on.
All right. We appreciate you being on board with us, Jimmy. Look forward to the meeting.
All right. Thank y'all. Look forward to seeing all y'all there.
Thanks, Jimmy.
I guess that gets us to the point where we have to elect officers again.
That's right. We got TCA 6218-106A4 just requires us to do that annually. It seems like we just did that since we did that, I guess, May, but we typically do that the first meeting of the year, so we're just going to get back on track and do our election of officers. So we just need a slate.
All right. What would y'all like to do?
I move to renominate Gary as chairman and Justin as vice chairman.
I have no problem with that. Do you?
A second.
All right. Very well. I guess we're still.
All in favor, please say aye.
Aye.
Any opposed? All right, hearing none, then that's our slate. Thank y'all.
Congratulations, Gary.
Okay.
Okay. Are we term limited after this? That's our second term now. I don't know. No. I thought, unfortunately, you guys can just keep riding that bench as long as y'all want to. We're a small group, so we kind of have to, it's nice that that you guys are willing to just cooperate and be able to participate in that regard. So thank y'all for serving, and hopefully we won't have to send you up to the hill anytime soon. But should we have to do that, where Gary, who might come down with something, then we'll have to send Justin up there. But nonetheless, thank y'all for keeping the continuity.
I think so far there's only been once where I couldn't make it out here, and the vice had to go ahead and run the situation. And then you all have the education report before you of the less this time than usual.
Unless there's any discussion on any individual course, I move to approve as printed.
Second.
All in favor, say aye.
Aye.
Very well. Now that takes us all the way to the director's report.
Both of these items are just informational. The first one is the budget. Let me get in there myself. All right. At our last meeting in November, we covered all the months of record available to us at the time. That was July through September. As a result, we'll be focusing primarily on the last 3 months of record, which is October through December. We had an uptick in expenses in 2 places under technology for October. So if you want to take a look at that, you'll see technology. There's two spots in October, both in technology, one under Edison, one under admin cost specs. So that was basically to cover our share of divisional supplemental contract, which covers the 6 months of the 6-month gap between our old core contract that ended in 6/30/2024 and the new core contract that started on January 1st of this year, and was resulting also from some enhancements made to several of our applications available in core. So, we were in negotiations for that contract. They basically gave us a maintenance contract is what it was, a gap contract to keep so we can maintain continuity. And so what you're seeing is that proportion across the division, and that's our program share. That's what you're getting there. A couple other places that jumped out at me as well. There was 2 places. There was salaries and benefits under admin cost specs for November, and then other expenses under Edison for December. So if you want to take a look at that, you'll see a reallocation under salary, that brackets under November, about midway down, that $12 sort of reallocation. That reallocation was resulting in a credit. That credit was due to an adjustment in salary. Admin was incorrectly billed for several periods for an employee. That's not in administration. This was corrected, and then admin was credited back the amounts, which were then distributed across the programs accordingly. So that, as a result, that resulted in that reallocation. So that's always good. We always like to find money, and our admin's really good about looking at the books, and anything that doesn't quite square, they're going to challenge that and question it. Sometimes it takes a while to show up in our months, but that was one of those items. So as for the uptick in December under other expenses, look at this December, work your way down there and other, that 1900 box right there. That was due to an expert review invoice coming through for prior work done on behalf of the board. So that's the only thing that I saw that just jumped out at me. Anything else you want to talk about, we can, of course, address that. But yeah, as you know, this will be a renewal year at the end of this year, but being that it's a non-renewal until we hit the end of the year, we're going to be running in the red. So that's other than that, though, that's to be expected. Any questions?
Pretty straightforward.
Hearing none, I guess we can move on.
All right. And then the other item, let me get there, is the A&E reference manual. There is a highlight on page 36. It's the last page of the reference manual. If you go to the very end, it's page 36, 39 of the document. You'll see a highlighted point there. It's use of publicly available mapping data. And so the A&E board, they were updating that as a professional courtesy. Obviously, that's y'all's territory in there, so they want to make sure that they check with you guys first. But engineering committee there, just interested in your feedback. It's, again, the reference manual doesn't have the weight of rule or law, but it's rather a guide, so keep that in mind. This isn't new regulatory territory. I think what they're trying to do is they're trying to let folks know that if you're going to be using mapping data, that's surveying data, or incidental, but don't use publicly available sort of data is ultimately what they're saying, and bringing that into your design concepts, or those things. There's a process for that. So that's and when I say that, that's their recommendation, generally speaking. They're not putting forth new prohibitions. At the end of the day, the statute and rule make all those determinations, and then you stamp it and assign it, then you're responsible, and you got to demonstrate competency, whether that be the three-legged stool, So all those things still apply. Again, this is just a guide in case someone was to look at their manual and need some help.
I tone in on that a little bit?
Yes, sir.
I'm glad to see this being addressed by the engineers board. This is a topic that has been coming across my desk in terms of other surveyors across the state calling me, asking opinions and questions on this. More specifically, although this doesn't say it specifically, more specifically, I think it gears towards the available LiDAR data that's produced by TDOT. I'm almost sure that's where this is going, although it doesn't say it specifically. And I don't know that today's a day for discussion. I don't have specifics on TDOT LiDAR data with me today. I wasn't prepared for a discussion on it. But I do want to at least recognize and applaud the engineers board for bringing this up, and perhaps it'll open the door for further discussion in our board about this TDOT LiDAR data. And my opinion on it personally has always been it's a great planning tool, and which they kind of allude to here on their statement. But really, it's kind of project specific as to whether it should or shouldn't be used. Again, I'm not going to get into specifics on that today, but my point being is that I wanted to applaud the engineers board for bringing this up and putting it in their policy here, and perhaps we can bring it up ourselves for further discussion on it.
And you're correct. That was the example they used, was TDOT LiDAR. Yeah.
Yeah, I think.
And I agree with you, Jay. I think this is a good step. One little point of clarification, it's not TDOT data. It's actually federal data. It's USGS 3DEP data. TDOT administrates it for our state, just makes it available because they've got the infrastructure for it. But just so that, just make that clear. That's the feds are putting that together.
That's a good distinction. So I'm glad you said that.
Yeah, I think the statement's a good statement. I mean, it need to be some guidance out to make, and that was our fear more on the surveying end, is that people were using it for final design on projects that really needed more detail than what they were really getting from the state available data. It's certainly a good planning tool. We've been using aerial mapping provided by various counties for planning purposes for as long as I've been in the business, but you have to recognize when you have to go over to more detailed data into it, and it is project specific. There are projects that can easily be done using that level of information, and that's something that the design professionals need to be aware of making that decision of when they have to have better data to work with it. So I have no problem with this statement.
Yeah, Jason Carter, he put that statement together. He'll be at the conference with you guys, coming in there in Little Rock. Okay, well, I'll let him know then. So I'm sure we'll see them before your conference. So I'll let the board know and report back to the engineering committee. Thank you for your review. I appreciate that. Looks like we're then ready for legal.
Okay, thank you. This is Erica, and I'm going to present this very long legal report, so please bear with me. Number one, 2024045921. Respondent was hired by a licensed auction to conduct a survey of a 100-acre tract for the purpose of dividing it into two parcels. Respondent completed the survey, and complainant ended up purchasing one of the 50-acre parcels at auction. Complainant alleges respondent should have known of septic easements and failed to include them in the survey or disclose them. I'll also note that this complainant filed a complaint against the licensed auctioneer in this matter, making the same allegations that the auctioneer should have known about the septic easements on the property and didn't disclose them. The complaint was already presented to the auctioneer commission, and it was dismissed without action. Respondent's attorney provided a detailed response arguing that respondent's scope of engagement and standards of the land surveying profession itself clearly show there should be no liability. for these specific allegations. Respondent further argues that a standard property survey, like the one they completed, is neither designed nor intended to detect or inspect for all possible easements, particularly those that may not be visually apparent upon physical inspection. Respondent believes they've fulfilled their professional obligations. They provided an accurate survey of visible property features. They included a disclaimer regarding easements, explicitly advising that an independent assessment for easements should be conducted. A title search also failed to reveal and identify the septic line easement referred to here in this complaint. The only time it came up and the first time it came up was when complainant told respondent about it because their own neighbor, let them know of this existence of this septic easement. And then respondent conducted a thorough search of recorded documents, which eventually revealed an easement description for that septic easement on the adjoining property. It's important to note that this easement description did not encompass the septic lines on the property at issue that was actually surveyed. So based on all of this information, I do not believe there was a reasonable expectation for respondent to discover the underground septic field lines. So I don't find any evidence of violations, and I recommend dismissal.
Okay. This is not the one you were, okay, we'll make sure of that. I guess briefly, yes, I tend to agree with the recommendation. Interestingly, I've actually done a few cases where this type of information was involved. We certainly, by our own standards, are required to show any easements that we were made aware of, that were evident, or were provided with documents to cover it. The question comes up is how far back are we as the surveyors required to research? We know the title companies rarely go past 30 years, and that these days there are interstates and TVA power lines that were put in the 40s and 50s that don't show up on a title search. But obviously they're there, and we know enough, then we are need to come up with information on it. Septic fields are, very rarely can you tell that there's a septic field out there. If the owner had come out and pointed out that there was septic fields in there, then I would think the surveyor would have had some culpability here and have to follow up on it. But in this situation right here, I think they did both what was within the standards of practice and what would be a standard of care as well.
Yeah, I tend to agree with what Gary said. There's only so much that the surveyor can do, and unfortunately we don't have the X-ray glasses on, although maybe I do, X-ray glasses on to see beneath the surface. And it sounds like on the survey itself it had disclaimers about just those kind of things. It looks like a title search was even conducted and didn't come up with any kind of easement on it. There's only so much that the surveyor can do, and I feel a little bit for the surveyor there. I can kind of fill in his boots there and understand where he's coming from there. Just unfortunate, it is. I don't know if the property was developed. If the property had some sort of a building on it that had plumbing systems in there, then you'd have to assume that there was either public sewer available, probably not in this case, or a septic system.
I don't think it was developed, by the way.
I kind of didn't. Yeah, I didn't think it was.
Yeah, I took it that these were septic fields that served a development next door.
Yes.
Which happens quite often, so that would have been really
Quite
hard
often,
to come up with.
Even more so.
I've stumbled on those that they pumped the drainage over 2,000 feet, and we came across a septic field that was that far away from the nearest house, and that's hard to go with. And the owner of the property has to accept a certain amount of responsibility as well. I mean, that is pretty much our common law on property, is that the owner is supposed to defend and know about his property, and if he was aware that he had septic fields on it, then he should have pointed that out to the surveyor.
Certainly. Yeah. So I agree with the recommendation from staff there.
Just a quick question. Is there a type of survey that would require you to, for that to be looked into?
Contractually, they could have added that in.
Okay.
I would feel that's above and beyond what this normal standard of care is, or what's in the general boundary survey requirements inside of our own rules. But yes, things like in a Alta NSPS survey, they can add that as a requirement if it's something they're interested in, to do the extra research it would take to find a septic field.
Yeah, the reason I asked is because I flipped a house once, and the property beside us, when I started looking at the drain field, I realized that their garage, the neighbor's garage, was built on top of their field lines.
Right.
And I just wondered,
No, it can come up. Anyone who's done survey work for TDOT for roadways, that used to be in their standard, that you were supposed to interview the owners and ask if they knew where their drain field was, or if they were on a drain field. It's the same way, and I do a lot for gas line transmission lines. It's the same thing. We have folks that interview all the property owners on the route to see, and that's what we really depend upon, because you can't really detect them. I'm not even sure ground penetrating radar does, other than the lines on it, because it's so often it's just gravel.
Yep.
What you come up with. So no, in the absence of it being added to the contract, I don't see that the surveyor has.
Understood.
It sounds like we're heading we have the formation of a consensus, so we'll need to memorialize that for 202-404-5921. That's case number 1. The recommendation was dismissed. Do we have a motion in that regard?
Motion to accept the recommendation from staff for dismissal.
Got a motion from Jay Kaufman. Do we have a second?
A second.
Got a second from Kevin Martin. All in favor, please say aye.
Aye.
Any opposed? All right. Hearing none, then number 2.
Need someone to turn off their mic. Thank you. Okay, number 2, 2024-056-161. Complainant stated respondent conducted a survey of the land where their home is located in September of 2016. Complainant alleges 3 individuals were, quote, stealing their farms, mineral royalties, and the LLC holding their land, end quote. Complainant makes further allegations against a judge, the local police, and other individuals, claiming they have all plotted against complainant. Complainant alleges every transaction in the community involving them is laced with fraud. Complainant alleges respondent completed a new survey to put up stakes due to a boundary dispute with their neighbor, who also sold them the land that's at issue in this complaint. Complainant feels like they lost some land with the survey, but claims they told respondent to give any small question of boundary to the seller, who's also their neighbor. Complainant claims certain individuals, including the seller's daughter, worked with respondent to relocate their property stakes and redraft a new survey taking away half of an acre of their land. Complainant alleges respondent and other individuals were involved in sending gangs to their home to steal the original survey, and they intentionally stole acreage from their land. I just want to note that complainant did not provide any kind of evidence or documentation to support any of these allegations. Respondent denies being a clog in the alleged wheel of widespread corruption mentioned throughout the complaint. Respondent confirms complainant requested that they return to their property to replace a southwest corner, which had allegedly been knocked down by a neighbor who is also a farmer that farms some of that property adjoining their property. Respondent had originally created 2 residential properties for the original landowners of the complainant's property, which refers back to that original survey from around 2016. And then they actually divided this property way back in 2004. When respondent returned to the complainant's property as requested, they located all of the existing corners of the lot prior to reestablishing the southwest corner. Respondent found their original capped iron rod at the southwest corner, noting only the witness post had been knocked down. The rod conformed to its original location, and respondent replaced the witness post. Respondent states complainant was on site and was happy with their work. Respondent mailed a copy of the recorded plat from 2004 for complainant's records. Respondent does not know what complainant's basis is for being shorted half an acre. respondent was never informed of any of these alleged issues until complainant filed this complaint. I don't find any evidence of violations and recommend dismissal.
I got no comment. I agree with the recommendation.
Make a motion to accept the recommendation from staff for dismissal.
All in favor, say aye.
Aye.
Okay. Number 3, 2024048751. Complainant is a licensed land surveyor in Tennessee and alleges respondent is surveying without a license. Respondent is an energy company who works throughout North America. Respondent contacted complainant in 2022 requesting access to their property to conduct various types of surveys as part of an expansion project related to pipelines. Complainant denied access and demanded to know who the project surveyor was and further demanded certified boundary surveys showing all of respondent's findings. Complainant hired an attorney and took respondent to court. The court held that respondent did not have to provide any of this requested information due to eminent domain. Complainant provided over 100 pages with this complaint. I had an expert review everything. The expert summarizes that respondent was tasked with building an additional pipeline within an existing easement. This project seems to fall under the Federal Energy Regulatory Committee. Respondent initially reached out to complainant requesting permission to conduct a 600-foot wide corridor survey, which would include a civil survey, cultural survey, endangered species surveys for both plant and animal. Complainant denied the permission, told respondent they needed to observe the limits of their existing 50-foot right-of-way. Respondent acknowledged the denial of the complainant's request to come onto their property. They forwarded it to their legal department. Complainant did note that respondent's representative met them on site and brought along a GNSS receiver. Complainant also provided 3 unexecuted easement documents, presumably associated with the pipeline construction on complainant's property. Within these documents, respondent produced 3 easement exhibits depicting the existing easement and an adjacent proposed temporary workspaces. The expert notes the easement depicts the pipeline to be constructed and describes its points of beginning and point of termination with coordinate values. No courses and distances are shown, only offset distances and area dimensions. Property lines are depicted but not labeled with bearings and distances. They're just called out with a PL line type. So based on the information provided, and in summary, respondent has collected information with a GNSS equipment for the design and construction of a pipeline and its needed easements and workspaces. While this is typical of the work a land surveyor commonly does, the expert believes that survey equipment is regularly used in utility, engineering, and construction layout surveys where unlicensed individuals commonly work. The exhibits respondent prepared in support of the easements seem to be carefully crafted to not show annotations along property lines and also do not fully annotate the easements. They do define areas with acreage values and show beginning and end points of the proposed pipeline with coordinate values. In the notes section of the exhibits, respondent states that the work product is, quote, an easement exhibit based on a route survey and does not represent a property boundary survey. Property lines shown herein are derived from GIS data and not indicative of boundary evidence, end quote. The expert believes the one item that the board may take note of is the fact that respondent is showing a coordinate value at the beginning and endpoints of the proposed pipeline, which is also graphically depicted as points along the property lines. By assigning coordinate values to those locations, it could be interpreted that respondent is offering an opinion as to where a boundary line is. The expert believes that respondent is operating in a space directly adjacent to and perhaps running coincident with the realm of what we consider to be land surveying. However, the expert does not believe sufficient information has been presented to find conclusively that respondent is practicing land surveying without a license. The easement locations are derived from existing locations of a pipeline in the ground. It seems reasonable that the pipeline company or its subconsultants are the logical entity to locate the pipeline to correctly identify the easement locations. The respondent did not provide a response to this complaint as requested. I recommend some discussion if you feel it's necessary as to whether all of these detailed opinions by the expert lead you to believe this is unlicensed land surveying. I will say we also don't have any information as to whether a licensed land surveyor was involved in this. The expert and I both agree that there could be. We just don't know because we don't have a response. And the court has made it clear that they don't have to give us any, not us, but the complainant anything. Therefore, we don't have what the complainant doesn't have.
Thank you.
You're welcome.
That's as usual, that's a fair amount of information on that. I actually have some expertise in pipeline corridor surveys, and I can just briefly say that what you reported here is indicative to how we generally go about the process, and that the multitude of natural gas companies that I contract with have in their regulations that once it goes into when they actually have to have real civil surveys or property surveys, that they will be done in accordance with whatever state's requirements on that. So it would surprise me that there wasn't a surveyor involved in this somewhere, even without asking the question, because that comes up all the time. I'll address that normally before anything like this is done for a transmission line, they send out notifications and they wait 30 days for response on that. And this is to kind of trigger this eminent domain and condemnation process when it becomes necessary. And it's not unusual that we will come up with resistance from the owners, like in this case. And all these surveys are talking about the, bats and things, and there's a lot of stuff that it's not land surveying. This is just going out and counting endangered species, endangered flora. Is this a bat migration area is a big thing, and even noise levels and things. It's quiet on that, and we can, once the 30 days have passed, as I understand it, we can, under their umbrella of eminent domain, start doing the surveys, even if it is a real boundary survey that we go into. But it's also, if they were only planning on putting an additional pipe inside their existing easement, in those cases, rarely do we do much surveying for it because they have the easement. I can see where they would ask for a temporary construction easement because it would make it easier. Generally, the easements are wide enough to put a second pipe, but they may not be quite. If they try and build a second pipe inside it without any additional easement, they end up having to do extraordinary efforts to protect the existing pipe. So gaining an additional 15 to 25 feet of temporary easement for the construction is fairly normal. And in those cases, rather than base it on a survey, since it is a temporary easement and sometimes just comes in through by letter of agreement, they do not produce a full survey. And, to me, that's kind of a description where you're saying we want to temporarily acquire 15 feet that is adjacent to this property line or adjacent to our easement, is that anybody can write that description, and it's actually something that could be reproduced as necessary. The acreage and length is just to quantify plus or minus for compensation. And that's all that's for. And if the owner disputes that he thinks he owns more than that, then they will typically just say, how much do you think you own? We'll give you that much money, because it's a temporary, it's going to go away, and the only reason they go for it is that. The coordinates along the line are purely for navigation, for anything else. It's just if it is something we're going to go back and do a survey, typically I will send one of my staff along with the designers who are doing the preliminary route walk to find out where they want to put it, or I will, if they have somebody who can actually operate and understand, we'll give them a full surveying GPS unit. So anything they see that we need to dodge or be aware of, they will take coordinates on it so that we can go back and find it and do a more detailed survey on it. So those type of coordinates are purely more navigational than anything else. And I say, to me, there's nothing done wrong right here. If they had started turning out real plats, which is the next step, if we actually are acquiring easements, then we have to do real plats with real descriptions and real boundary lines, and certainly the surveyor has to be involved at that case. And in this one, since they didn't mention, we don't know that the surveyor wasn't involved.
Right.
In my own efforts, I am involved in telling them what they can do and can't do to kind of keep everybody straight on that. To me, this is more, the thing driving this to me is we've got an owner who doesn't want the gas company there at all.
Absolutely.
And-
That's pretty clear. So my recommendation was dismissal, if you want to discuss that possibility.
And I agree with that. Any question, thoughts, or other comments?
My question, so the respondent never responded?
No. But they're not licensed, so they're
We
not
don't know.
required to
Didn't we-
respond to us.
But we've said we don't know if they're licensed. or
Right, I mean,
not.
like the company, itself, but of course, they very well, this is a very large company, it's been, seems.
And I guess that's my only point is.
They very well could have a
everything it says here, I recognize as the way that I would normally do this job.
Right. But that's my only concern a little bit is couldn't even get a response out of them to.
I think if we had proof of some survey that would require a licensed land surveyor, then we could move forward and require them to respond or hold them accountable for not responding, because then they're engaging in something that requires a license. But because we don't have that yet, I don't think we can necessarily hold them accountable for not responding.
And you've seen existing pipeline easements that are very easy. If you're going to stay in the easement, it's not that hard because they keep that clear cut,
Yeah.
and usually has markers along the way as well.
I'll chime in here a little bit. Certainly, I will yield to the expertise of the chairman here, who has direct experience on things like this. But a couple things. Again, I'll reiterate: we don't know if there was an RLS involved here or not. So, I think that says a lot right there. I am aware that in some of our adjoining states, Alabama, Mississippi, both expressly have exceptions for utility companies in terms of easement acquisition. And I think also in terms of doing work on military-type bases as well. So I know some adjoining states do have some exceptions specific for utility companies. I'm not aware of Tennessee having anything like that. In my research of the rules, I'm not aware of any TCA that has that. It may exist. I'm just not familiar with it. So that does bring the point that if they're doing boundary-type issues, if they're doing boundary-type issues related to easements, that I would infer from not knowing of any exceptions that a Tennessee RLS should be involved. However, it sounds like an easement already exists here.
Yes, definitely one exists.
Not looking to expand the existing easement other than perhaps get an adjacent temporary construction easement.
Right.
So we, based on the original easement already being there, I would assume that it gives a length and a width, et cetera. They know the area of it. They can, based on that calculation, calculate an approximate area of the adjoining construction easement. All standard practice here, which could be done with a written description that doesn't involve an RLS involved there. So all that being said, I would tend to agree with council's recommendation for dismissal for a couple reasons here. Number one, I don't know that an RLS would directly be involved or need to be involved for the temporary construction part, being that there already is an existing easement on there. I assumed an RLS was involved in that. And secondly, of course, the involvement, or not involvement, but certainly the experience of the chairman here, based on his words, that he didn't see anything uncomfortable. I'm not trying to put words in your mouth, but
No, I'd say if they were acquiring a new easement, certainly under our rules and most of the states that I work in, yes, a surveyor would have to be involved into it. If they're working within their own easement and there's nothing really happening with new property line surveys and all, and I've got to believe that they have a surveyor involved, making sure that they were didn't cross that line, because that would be standard practice of that.
So again, we
I
don't
can
know that a
understand them
surveyor
not
wasn't.
responding. They get so many complaints by attorneys that that's just a,
And these were in-house forces that worked directly for the gas company. This wasn't a third party providing. Do we know that?
Providing what?
That did the field work. Do we know that they were employees of?
probably
From
not
what,
employed.
from what I can tell from what the complainant gave, yes.
Probably a subcontractor, I mean,
mean-
because that's what they hire us for, is to go in and study a route. And, the first part of it really is a planning thing. We're using aerial maps and whatever just to decide where a pipeline might go. In this case, if they're just adding a line into an existing easement, that's where they're going to try and go most of the way. But probably not in-house, probably a contractor.
Okay.
Further discussion or recommendation or motion?
I have a recommendation to accept a motion to accept the recommendation from staff for dismissal.
I second.
All in favor, say aye.
Aye.
Okay, that takes us to number 4, and we may want to have, when do we need to do a recusal? Do you want to recuse?
Yeah, just as soon as you read it in.
Okay.
Yeah, then,
I think wait,
Nope, not this one.
not this one. Okay, never mind. Sorry about that. Okay, number 4 is 2024-063-521. Complainant is a resident of Mississippi who hired respondent to complete a survey on July 24th of last year. Complainant states the survey was completed on August 19th, but claims they received a land survey and an air survey despite only requesting a land survey. Complainant alleges respondent did not stake the property or meet with them to clarify the property line. Complainant further claims they needed the survey to identify the location of an advertisement sign on the property. Complainant alleges respondent ignored their emails and states they have been forced to hire another land surveyor due to respondent's failure to provide necessary information. Complainant makes allegations that this is racially motivated and notes complainant's race in their rebuttal. Respondent states after receiving a request from complainant to revise the land survey and clearly specify the location of the sign on the property, they responded with a revised survey that showed in detail the location of the beams that support the billboard, along with the signage and catwalk that encroaches on the complainant's neighbor. Respondent states the original survey also showed these elements, but they scaled up the area for what respondent thought would be clarity and would, I guess, give the complainant what they were asking for. Respondent feels they made the requested information very clear and notes complainant may not be well versed in reading plats or maps. Respondent further does not know what complainant means when they refer to an aerial or air survey, as nothing of the sort was completed or provided. Respondent believes complainant is unhappy with the results of the survey and claims they are being harassed. Complainant filed this complaint with the Attorney General and the Better Business Bureau as well. Complainant also filed a dispute with their credit card company to get the $1,500 refunded. The credit card company denied that. Respondent did provide the survey, field notes, and the record plat for review. An expert review was conducted. The expert states the survey at issue appears to satisfy all of the complainant's requests. So all of the allegations made by complainant, the expert did not find any proof that those allegations were true. But on a completely separate note, the expert notes that the survey itself states that it's a non-monumented survey. So the expert questioned whether that is reserved for closing or loan surveys based on TCA 62-18-126. The expert asked for review of this issue, so I had a different expert reviewer review that question and provide their opinion. The second expert states that it is common practice for surveyors to put these statements on a survey that is not a boundary survey, whether or not monuments are shown. The second expert also notes the policy statement that we have that was issued that states TCA 62-18-126 authorizes land surveyors to perform certain limited non-monumentation procedures and practices. It is the policy of the board to consider any survey plat as a general property survey to be regulated under the standards of practice if it is sealed by the licensee and does not specifically state on its face that, one, the survey was done under the authority of TCA 62-18-126, and two, the survey is not a general property survey as defined under Rule 0820.03-7. After I provided this legal report to you all, I got a little bit more information from the respondent because I was trying to understand what kind of survey this was, since it stated it was non-monumented and I wasn't clear. And I asked this surveyor a few times, and the best response that I could get was, quote, "This was originally intended to be a non-monumented survey that happens to have been monumented." And that was the best answer I could get. So I don't know if that makes any difference to you or what that means to you, but it does confuse me a little bit. So based on all of this and the second expert's review of the matter, I recommend a dismissal, but with that additional information, I don't know if that changes anything. So I just welcome some discussion by the experts in front of me.
Well, I think I'd almost like to see the map onto it, but as far as anything wrong with the survey, I don't see anything in there. It does, I'd be curious if the complainant was actually, it's unclear to me if the complainant actually asked for a survey, and mostly because he wanted to know where that billboard's set, or if he specifically told the surveyor, I just need to know if that billboard is on my side of the line or not.
That's what, from everything that I looked at, the complainant kept emphasizing that is what they wanted. They wanted to know where this advertisement billboard was. And they were unhappy with the results related to the catwalk.
That happens every so often, that they complain because they didn't like our answer.
They kept wanting the respondent to change that aspect of it.
But did the survey show the entire boundary?
Let me pull it up. I believe that I have it redacted. Mm-hmm. So I feel like I could probably show.
Well, it's more of if it shows the entire perimeter with calls on it, then I tend to say, well, that's just a general boundary survey, regardless of them trying to note it that's not.
That's what I thought.
I don't see anything wrong with what the surveyor's done here, and we've all been in that situation where they didn't like the result, or they couldn't read the map, or what they were looking for was a line of stakes out there on the ground to show where it is. But I do take issue with, just as a matter of course, using that non-monument survey disclaimer on that, because that's not really what that was meant for. It's not meant to be used to get you around the requirements of a general boundary survey. Now, if the map only showed that one line and its relationship to the billboard, I can understand not setting a missing iron rod there and mentioning that it's a non-monument survey, because they've fulfilled what the request was. But if it shows the whole boundary, then it's just a general boundary survey. This thing on the title surveys is what we used to call mortgage surveys, and it was back when we were having a real argument with that, of whether or not they needed to meet the general property survey requirements. TAPS was floating laws out to clarify that all surveys had to meet all the way through. The banks and mortgage companies came back and had this TCA inserted in to cover what they were after, and that's small, I'll call them residential lots, quarter-acre type things, and all they were really interested in was enough of the survey to show that the house was within the boundaries of it. And it was, at that time, folks were building their business on that type of survey, and they were going for about $200 a piece, and people were doing as many of 10, 12 of them a day and turning them out. So it's a very specific type survey that they put in that, and it was never meant to be used to get you around of doing, and that's why it's worded the way it is to be, that was the surveyors involved in it, added enough worded to make sure that nobody used it to get around just doing a general boundary survey. So, and if that's the general part, and if it's a standard of practice in that area, or not standard of practice, standard of care, I don't think the standard of care can override our rules and laws, that we have to go by those over top of it. I tend to want to dismiss the charge, but write him a letter of instruction or something saying, please quit doing that.
Using this
Yeah.
to get around.
Yeah, quit. So that on the well, I'd be, it says on the surface, it looks like that you may be using this to get around the regulation, which is not his intent. Please be a little more use a little better judgment of when you use that one.
Okay. I mean,
Something to that effect right there.
Right.
Anyway, I thought I'll back it.
Yeah,
I mean, I have the redacted map in front of me if it would be helpful. It would remain anonymous. You can see it because the expert did that, wanting me to, get an opinion on it, the first expert. So if it would be helpful, I don't see anything wrong with me showing it. I could bring it up to you if you would like.
I think you may be able to answer the question without showing us. Does it show the entire property itself, or does it just show like one property line, two property lines maybe, in the relationship to the billboard?
I mean,
Okay.
I'm thinking this, here's the billboard, and they've scaled it. And which is right here, I'm thinking it's an entire property.
It does look like one piece of property, and then there's
Okay.
There's a little
A little
billboard
square.
sign that he's got
that's-
scaled up.
that's
He's got
the-
scaled
They
up.
did an
Exhibit.
insert, blew it
Yeah.
up, but they've shown the
Yeah.
entire property.
And
Okay.
I had some back and forth with the respondent, trying to get this respondent to be clear to me. And they just stated it was originally supposed to be a non-monumented, and then they contacted me about some boundaries, or
It bothers me a bit that he's being that elusive.
I know. I was a little bit frustrated because I just kept explaining, I need to be able to answer these questions when I present this case, and the more information you can give me, the better everybody can understand what happened here or what didn't happen here.
Yeah, to me, the proper response would have been that, yes, the purpose was to show which side of the property line the billboard was. I just showed the rest of the boundary to give it a picture for information purposes. And then I would have been cool with it all the way down.
Yeah, let me see if there's anything else in this.
I don't know. I think I might make the argument that you could show one line and it'd still be a general property survey.
You could.
If you're identifying that property line to determine whether or not there's an encroachment.
Well, I'd agree. That's why needs to be a little more judgment in the use
Yeah,
of that statement.
I think any way you slice it, this is not appropriate place to use that disclaimer.
And you're right. The original intent, as I always have understood, agrees with the way Gary phrased it, was these are for what we call mortgage surveys. Back 20 years ago or so, they used to be rampant in the Memphis area. Like you said, $200, $250 a pop. These were subdivision lots where a house has been built. They wanted to make sure the house is inside the setback lines. Rarely were monuments ever set for any reason. It was just, they were doing multiple of these a day. That was the intent of this, as driven by the real estate lobbyists, et cetera, et cetera. That was the intent. Because, in terms of the real estate agent, their point of view was it's another piece of paper in the stack and a checklist, why is this costing so much? We got to, so that was the intent. I've never really seen it used to an extent like this, other than mortgage surveys, which, again, I rarely see anymore. So that is where really my eyebrow is raised, is it's just kind of an unusual application of this. Now, if we didn't have policy, as is written in these notes here, I would be a little more suspect of what's going on here. But the way the policy says, it doesn't exclude
Right.
anything. It just says, in the practice of a plat is a general property survey, unless it states, and it lists the TCA, which my understanding he has done on this survey.
Yeah.
So it kind of took the fire away from where I could go after this. I like the way Gary approached this. I think a letter of warning, is, and maybe we can discuss where we want to go exactly at the level of this. I don't think it's disciplinary action. I really don't, because I think he's complied with the rules and policy as we've listed them. We kind of did this
Right.
to ourselves in a
Right.
sense. Maybe it's something we need to readdress. Again, it was not the intent to be used on this, but I think it doesn't say that it can't. So, excluding any other, issues with the survey that I'm just not familiar with, I think a letter of, at least instruction, perhaps a letter of instruction might be the best.
Yeah.
I
Let me,
never
Guys,
can
here,
keep
that
straight
was
of which
not
is
the
the proper
intent.
term.
let me tell you, I'm just going to give you a little more info between my conversation with this respondent after I submitted this, or I would have included it, in case it means anything or changes anything. They said, we were originally hired to do a billboard location survey. Later, the complainant contacted us regarding locating the property corners. So I asked for some more information. Please clarify what kind of survey this is, this final product. And they said, well, we never revised the statement that I've quoted about the non-monumental survey. And they state, it was originally intended to be a non-monumented survey for the purpose of locating a billboard. Upon doing the survey, we discovered that all the monuments were in place. Just because we state that it is a non-monumented survey doesn't mean that we can't go beyond that and locate the monuments as in this case. So that's kind of everything I have. I thought that might be helpful, is it?
I was going to ask that. I'm glad you read that because I was wondering, like, why would you go seek the monuments if it's not necessary to identify something? So it sounds like that kind of explains why they went after that.
Right.
So for me, that gives some clarification anyway.
Well, it's clarification, but I still think it's an inappropriate use in this situation for it because it's like, just in case.
Yeah.
We have the same thing on these
Get out of jail
maps
free
and
card.
plats that
Yeah.
if it's just a map for a temporary exhibit, we put a statement on that it's not a survey, and that's required for us in a lot of jurisdictions by the Register of Deeds, who doesn't want to put an exhibit to a deed that looks like a survey unless it is signed by a surveyor and meets all the requirements. But still, that is not meant to get you around doing what you're required to do when it's appropriate. And I think this a letter to me, a letter just stating, and I don't even want to accuse him saying that you did this wrong. Just say you may want to think about this. Use a little more judgment of when you use this statement, that it's not meant to be a catch-all to cover anything you might have forgot to do.
Yeah,
Is
I
it the
mean,
board's opinion that it maybe should have been revised once the purpose changed, or,
Certainly.
okay.
Yeah, because that's the thing. It doesn't look like he did anything wrong. He did a proper survey, so this
He doesn't
note
need the
is
statement.
meaningless. It
Yeah.
was unnecessary.
So just leave, maybe it would have been more appropriate to leave that statement out?
Yes, yeah, it just
Just
didn't
want to make
belong
sure I
there.
understand too. Is there a statement that should have been there instead, or that just wasn't? Okay, because if it's not there, then it's considered a general property survey, is that correct? And that's what may have been more appropriate here? Okay.
Yes.
Okay, well, I think that would be a great resolution to this, a letter of instruction, which is not discipline, because I know
Correct.
you're questioning that. And also a letter of warning is not formal discipline, but a letter of instruction is more,
Instruction is more what I have in mind.
Yeah, a
is,
warning is
and I
when you
even
feel
actually,
something's
I don't
wrong.
want to even be hard on the guy. This is more of just some friendly advice and helpful that you may not have.
We're
This
not
is
accusing.
probably not the proper use of this term, and even if that's what's usual in your area, you need to quit.
okay.
So motion for letter of instruction.
Second.
All in favor, say aye.
Aye.
Okay. Number 5, 2024-065-361. This complaint was opened after respondent, who is a licensed surveyor in 9 states, including Tennessee, self-reported discipline assessed in Ohio. Respondent's license to engage in land surveying in Ohio expired on June 30th of last year, when the notice of renewal was eventually found in their junk email inbox. They discovered the lapse in July and took immediate action to renew their certificate. During that renewal process, respondents self-reported that one plat of survey had been signed earlier in July while their certificate was expired. The Ohio Board of Professional Engineers and Surveyors opened a complaint, which resulted in a violation charge, a $500 penalty, and a settlement agreement, which was signed on October 15th, 2024. Respondent self-reported to this board on November 30th, 2024, and they maintain a current and active certificate in Ohio, as well as here. I recommend issuing a letter of caution pursuant to Tennessee Code annotated 62-18-116A1, which states the board is authorized to take disciplinary action against a land surveyor's license in Tennessee due to disciplinary action taken in another jurisdiction. So a letter of caution is not formal discipline. It remains in their file. It's not reported anywhere. And if the board agrees on this, I also just kind of want to segue into something that's on our agenda that Glenn may want to also talk about further. We would like to propose that in this kind of case where somebody self-reports discipline in another jurisdiction just for operating on an expired license, so just for that issue alone, we would allow our complaint division to automatically send out a letter of caution instead of it having to come to legal and be presented to you.
Yeah, and A&E, they do that by policy already, and it's a cost savings, and it also maintains consistency as well. So you don't end up, nailing one and then letting another run off with a letter of caution. And we'll look at the letter. You've already read it, but it's basically just letting folks know that, hey, watch your license. You know what I mean? And don't do that here. Like we're aware, and it's in the file as well. So that becomes a aggravating circumstance should they do that here as well, because they've already received their letter of caution. So.
Well, it's an unfortunate circumstance, but I think that's appropriate just to be consistent and follow policy, because we are responsible to keeping our license up. And sometimes things happen, but I would agree with that.
Yep. Fully on board.
Okay. I think we have a consensus. Do we want a motion? Motion?
So moved.
Second?
Seconded? All in favors? Aye.
Aye.
Okay, number 6, 2025-001-721.
So I got to step out on.
You want me to read it first?
Yeah, that's
Okay.
fine. Just go ahead and read it. That's
Okay.
fine.
This complaint was opened after the board received anonymous information alleging respondent, an unlicensed individual, may be engaging in unlicensed activity. Respondent owns a company in Kentucky described on their website as a full-service forestry consulting firm serving all of South Central Kentucky that offers various timber-related services as well as, quote, property boundary marking. When you click on this service explanation on the website, it goes on to state, quote, once a property is surveyed, it is best to mark your boundaries and corners. Using a long-term tree marking paint, landowners and neighbors can identify property boundaries for up to 10 years. This company will identify and reestablish property boundary lines. This service includes identifying the lines between property corners, removal of brush and small trees from the line, and blazing and/or painting of the boundary. This service helps in conducting other management activities and can protect your property from trespass issues, end quote. The anonymous informant notes that there is no reference to offering services in Tennessee on the website, but respondent did reach out to a Tennessee licensed land surveyor asking for survey data, more specifically a boundary line information of a 450-acre farm located in Clay County, Tennessee, to, quote, load into a handheld GPS device. Respondent at that time didn't state what they would do with this data when they were asking for it. So the informant believed that it could have been inferred from the website services that it would be used to physically mark on the property line on that client's property. The email further shows the respondent asked for a digital copy of a survey and a GPX, KML, or KMZ file for the boundary line. So once respondent was provided with all of this, they gave me a lot of information. They were also, I just want to state, very cooperative, very open to whatever the board would like to instruct them to do and wants to make this right. They explained they're a consulting forester. They manage timber for private landowners. They're not a surveyor. They don't perform any kind of survey activities from what they understand. They have worked on the property in Tennessee in the past. They completed a timber inventory and appraisal of that for the landowner in May of 2019. That landowner called them a couple years ago, wanted to sell the property. So respondent advised them to obtain an updated survey and timber appraisal to help the sale of the property. The landowner then hired a licensed land surveying company, and with a licensed land surveyor in Tennessee, they completed an updated survey. Respondent then met the field crew when they came out to the property to help show them around since they had knowledge of it. Then respondent completed an updated timber inventory and appraisal. The lines on the property had been freshly painted yellow, and respondent assumed it was done by the survey crew. I'm going to kind of skip down a little bit just to move along here, but if you want to ask me any questions about this that I skipped over, let me know. But respondent basically has requested some clarification on the matter of boundary painting. I think that's also where the issue lies in the description on their website where they state they can reestablish property boundaries. I think that might be an issue. It may lead public to believe that they can establish them or reestablish them, which I think is a problem. But I do think the board should discuss whether or not, if there has been a survey done by a licensed land surveyor in Tennessee, can the respondent or anybody paint a line between one point to another? And I think that's what they're asking about. And of course, if the verbiage on their website needs to be changed, they would like instructions on what is problematic here. So I do recommend discussing this issue and whether the advertising of property line marking, identification, and reestablishing services without clearly disclaiming that a respondent or anybody else is not a licensed land surveyor is considered unlicensed activity. And if the board agrees with everything that I've said so far, I think a letter of warning could be appropriate to include any instructions that of changes that need to be made here.
And with that in view, if there's any recusals, this would be a place for that.
And being that, I am going to have to recuse myself on this one. I do have some prior knowledge of this case, so Mr. Chairman, I will refrain from discussion and decisions on this.
Very well. I think to me, I tend to agree that there's may not be anything wrong going on here, but I will say that in my opinion, that the actual marking and painting trees and marking trees along the property line that actually witness the property line has to be done originally by a land surveyor. Now, I have no problem with somebody coming back and refreshing that paint, and that's kind of the difference in the terminology I think they need to go for, is that and the way he said it can be very honestly misunderstood by the advertiser as well as the customer, but this is not too far off of the one that we're working on of the guy running around Seymour finding people's property corners for them without a license. And because the witnessing and the marking of the line carry as much weight as the actual corners. And that's where the rub is here, is that first time that needs to be done by the surveyor. And as far as whether they can do it with they have somebody else's survey and using the GPS equipment, that's more of a matter of scale. And if you typically, for a fence to be built, we may, if it's a residential lot and you can see between the pins, once we've marked them up and flagged them for the fence company, they may be using their own people to actually set the stakes to offset on that, but then that's the difference in that we've identified them and you can see between them, it's easy. Now, if you're just blundering through the woods with, and particularly if you're blundering through the woods with a handheld GPS thing, I don't really want you marking and setting something that the next surveyor might have to take into as evidence of how the line was. And I guess that's my basic thing on to it, is that, and I can't really tell whether or not they've actually gone to that extent, but I would caution them that, yeah, they really shouldn't be doing that. They need to have a surveyor come in and actually mark it. They are free to come back and add more paint or refresh the paint later, but they can't do it the first time.
Yeah, I'm 100% on, were exactly my thoughts. And I think the discussion of scale is important because, yeah, anybody can pull a string between two corners and say, yeah, that's the line. But when you're on a 450-acre boundary with a handheld, you can get off pretty badly. And the truth is, once the paint is up, the
It's
public is
become-
going to
It
assume
becomes,
that is correct.
evidence of possession and the evidence of a line that we have to take into consideration in the next retracement. So that is very important.
Yep. So I don't think there's anything wrong with them saying they can clear the property lines and maintain them and, like I said, refresh
Refresh
those
the-
markers.
Yeah.
To me, that's like driving a T-post next to a pin. There's nothing wrong with that. But doing the initial marking, I think is an overreach.
Yeah, we had something come up a few years ago for us on the board that they were about what color could be used, because the other thing I know that logging companies will do is they'll come in and just paint the last tree that you're allowed to cut down. They usually make sure that that's well inside the property line, and I think they typically use purple, and there was actually a law that was put up in public hearing that about what color paint we could use to mark things. So, I mean, we're not saying they can't use paint for their tree inventories. We're just saying they cannot mark the property line the first time. That has to be the surveyor.
Okay.
I feel like for their sake, it would, if it were me, I would want to include language that says, we can refresh the marking only if it's clear and present.
Refresh. We can refresh previous
Yeah.
boundary line painting.
Yeah, right. Because I could see, just like you guys said, I mean, if you swag or you guess or anything, then if I buy that property, I'm going to assume that's the gospel.
Yeah.
And now it's wrong, so,
That's a danger to the public.
yeah.
Okay.
So property boundary marking's a bad term.
Yeah, I would really want to disclaim that I'm not doing land surveying. and
I definitely think we need to add that.
Yeah.
only in the
letter.
event that they're clear and obvious,
Yeah.
can I touch them up, so to speak.
Yeah, instead of saying that to do property boundary marking, I would say that we refresh
Yeah.
boundary paint.
Previously marked
Or existing.
Yeah.
or existing. Yeah, I like that.
Because existing suggests that you could see it and.
But that is a business. I know surveyors in East Tennessee that they're hired to come back in and refresh their paint every few years. And of course, that's easier than cheaper than doing a survey from scratch.
Right.
Yep.
So I would recommend a letter
Yeah.
of warning with these instructions.
I agree.
Yep.
All right, you all need the motion second over there.
I make a motion that we accept your recommendation on the warning and the suggestions.
Second.
All in favor, say
Aye.
Aye.
Okay, the last case.
Sorry, guys, I don't know what's going on up there, but
Powerlifting going up there.
I keep waiting for somebody, like some legs to come through here at any moment, I don't. All right.
Oh my! I'm gonna get through this one quickly. 2024-014-001. Now this is one that's already been presented to the commission last year. I'm not gonna read all of it. It's very long, but the board had decided when I did present it to put this complaint in a litigation monitoring status because the complainant had taken the respondent to court. There was a litigation going on at that time, and basically the complainant was just alleging that respondent had held themselves out to be a land surveyor. They were working on a deal between themselves, and the court, or I was notified by both the complainants and the respondent's attorneys recently that this matter was mediated while it was in court, and then it was confidentially settled. So the actual case was dismissed in civil court. I don't have any details about the settlement. I wasn't provided any further information because it's confidential at this point. So unless you want to conduct further investigation on our end, I don't think we have enough information that I presented to you, because all we have is what I've already presented to you last year, that we have enough information to say that anything more than this person might have held themselves out to be a land surveyor. And I think the only appropriate action would be a letter of warning and how you hold yourselves out. hold yourself out to somebody that you might be working on a deal with.
So, thank you. So it sounds like he represented himself as either a surveyor or works for a surveying company.
And he
think that's
did
pretty
work
clear.
for a
He did work for the surveying
Yeah.
company. Okay. My real issue really goes back to the surveying company and how much supervision they have on this employee. Because
Yeah.
he seems to be, just based on the description here and the way I envisioned the way things unfolded, renegade's a little strong word, I think. I wish I could think of a
Well, they
less
don't work there
strengthened
anymore.
word.
I can confirm that.
That's fine, but at the time.
Yeah, at the time.
It sounds like what the employee on site and the adjacent property owner agreed to, this 25-foot strip, never really coalesced together into the final sale of the lot, is what it sounds like. There was a loss of communication in there somewhere.
Right.
And I kind of put that back on the surveying company, is the way I kind of looked back onto it. That was a plat was produced, if I understood, if I looked at it correctly. I think there was a drawing of the newly aligned lot minus the 25-foot. I think I read that in there. Please correct me if I'm wrong. And that someone was going to create a new legal description of that lot minus the 25-foot. And then when it actually came into the sale of the lot, all that kind of disappeared and the whole entire lot was sold.
Right.
Am I right?
Yes.
Okay, I want to make sure I understand it right. And that seems to be, the communication and the understanding of the personnel on site, and then what actually happened at the transaction in this plat, so to speak, seemed to have been lost somewhere in the middle of it. And so I kind of wonder if it's really a direct supervision issue on that employee at the time was employed by the individual representing the surveying company. I'm a surveyor working for a surveying company. That's really where I got questioned. I want to kind of stretch that into the other members here and see if that's what they read into it as well. The whole issue of all the other stuff was a lot of miscommunication that I really don't think we have any issues with. But I want to kind of see where the others go with that.
Yeah, I agree. Most of the rest of that is at worst is just fraudulent, but is not fraudulent as far as survey is concerned. That was just some shenanigans with the property. But
Right.
I agree with Jay, is I think at the very least that we have to send some kind of letter to the respondent here, who to me very clearly offered himself as a surveyor. You can't go out and say that I'm not really a survey, but I'm going to do surveying for you. That's still in violation. Yeah, so to me, that's a very clear violation. But I also agree that if he was working for a survey firm at the time and then that company got involved in for his over with, then the surveyor in charge of that company is guilty of not being aware of what's going on within his company. And that is a requirement as well. So it's like two letters need to go out,
Okay.
one to the company and one to this individual,
Okay.
saying don't do that anymore.
That can be done. Glenn, do you feel like we need to open a complaint against the employer? And then do I need to present it again? Or I'll open one, we'll send a letter to both the respondent and their employer, and that will be closed once those letters are sent.
Okay, we still. Not cutting you two out of it.
No.
We almost did.
No, I think you covered it well. That all makes sense to me, because, yeah, there seemed to be an element of this guy kind of operating on the side here, outside of the purview.
Definitely.
That's the way I read it.
He wanted part of this
He's
deal.
operating on
Yeah.
the side.
And he said what he needed to say, I
And-
think, and then it fell apart.
Yeah.
And the whole deal seems a little shady to begin with.
Yeah,
So
Very.
it's bordering on some ethical things.
So if he's unethical in his real estate sales business, then I don't expect much from him in his illegal surveying either.
Yeah, so I agree with the recommendation, the 2 letters of warning.
Yeah, I was trying to determine, what the onus is on the company who he works for. Maybe they had no idea that even this was,
Well, by the time, since they actually turned out the map, as I understand it, at that time,
they did know,
Yeah,
they had to know.
they
that.
should
Okay.
have.
So I would agree
And-
that they should.
And I would argue that RLS that produced that, the onus was on him to say, hey, I need to engage this client and understand what's happening right here.
Absolutely.
So, I mean, we don't have our guys go out in the field and come back and say, hey, I got us a survey, or just do it.
Right.
We're like, okay. So, yeah, it's on them as well.
Motion?
So moved. How about that?
Okay. So
Second.
moved. Second. All in favor? Aye.
Aye.
Very well.
Okay, that concludes the legal report. Thank you for bearing with me through all of that. I know it was a lot.
Always entertaining and informative.
Thank you. I'm going to take that as a compliment.
Let's see, I lost my agenda. What are we up to here?
I don't remember when that expired.
All right, this is that letter of caution that we were just talking about when we were at case number 5. Of course, you've seen the letter. That's our template. We just model after A&E, but some clarifying language unique to our board on that letter. So, I just commit that to you for your review.
I think we approved it already, didn't we?
Well, no, we approved that case, but I was just now the letter itself going out. Yeah, yes, sir.
All right. Motion to adopt the
Letter
template-
of yep.
letter of caution?
Yes, sir.
Yes.
Second.
All right, got a motion from Jay Kaufman, got a second from Justin Raines. All in favor?
Aye.
Any opposed? All right, hearing none, then that one's good to go. That'll be our process going forward for those particular cases. New business and then public comment. Unless you have any new business, don't forget your PDHs. Let me see what we're looking at there. Tell you about it. You got it. You've been on the clock for about an hour and a half, so I don't know if you do partial credit, but 1.5 or whatever.
Motion for 1.5.
Second.
All right.
All in favor, say aye.
Aye.
All right, so is there any new business? I just didn't want to forget that. Okay, hearing none, then we can move on to the public comment section before we adjourn. This is the last piece before adjournment. Do we have anyone online? Or anyone signed in online indicating no? And then no one present as well or signed in at the podium. So in that case, Chair, it's up to you. It's your prerogative. We can adjourn or...
Well, if we have nothing else to discuss on, I recall that we left anything unfinished the last time. I know we had addressed and actually put in about having a change in the responsible charge definition. But does that then require any action, or do we know where that is? Or
No, those are your rules. They're still. I mean, we have to have a rulemaking hearing. That'll be where you'll get another look at that. But and if there's nothing substantive, I want to say we had a rulemaking hearing. That was the. I can't remember. It's all blending together now. But if we haven't, then we'll have one. And if there's nothing substantive, then that'll move along the pipeline. But I remember we already got one bite of that apple already. So I think everything's in. It's in track. It's in the pipeline. Yeah.
How long is the pipeline on the other rule changes that we?
It can take quite a long time, but
Well, not specifically this one. I mean, there was a set of rules marked up before I came on the board that still.
Those rules have been filed with the Secretary of State, and I got notice that they're going to be effective in May, and we're getting ready to send a e-notify out that'll go to all the licensees.
Because I have some questions coming up of applicants of which rules do they need to match on their submittals of plats, the new ones that aren't there yet, or
that
the
was
ones
before my time, but I took over that package, and
it was actually before my time.
Yeah, they'll be effective coming in May. So that notice is on the Secretary of State's website. Then there's another one that's come through the pipeline. We're hoping to have that hearing maybe in May, but it could be the next meeting after that. So we'll keep you updated.
Thanks for straightening out the traffic. So we had the rulemaking hearing on the GPS language, and like you said, that was a period of time. And then the retrospective with the responsible charge, that's the one that we haven't had the rulemaking hearing yet. So then Kyle, he just jumped in it with both feet, and we put him to work as soon as he came on board. But thank you, Kyle.
I think the other thing that we've kind of started discussing and is still hanging out there is
the minimum standards of practice.
Yeah,
Yes.
whether it needs to be Tennessee specific or.
Yeah, we talked about that one, and that's going to require a rule. I actually wrote down, I know you guys. I'm ready for you. And so anyway, That's going to require a renewal, a rules package. And since we already got two in the pipeline, this renewal cycle is coming to an end, so it's going to be the old process. But then we will get started on that after this renewal cycle. Yep. And then we'll lock that down with all the clarifying language per the desire of the board.
We're not doing policy anymore?
No,
it's been a while.
Yeah, we try to stay away from that.
Yeah,
There's been a shift away from that by administration, and rightfully so, because you saw where we ran into a policy before, and sometimes you try to clarify stuff thinking you're closing those loopholes, and you're just opening up loopholes based on interpretation. Happens all the time. So really the best way to guard the board's expertise and their discretion is just very clear rules and statute, and then that's why we're really even policies, we're trying to get away from that. And then we have some guides, but we heavily disclaimer that and wrap that thing in, that this is a guide, this is best practices, doesn't remove the discretion of the board, all that kind of stuff. Yep.
Yeah, problem is that some of these things we're addressing that when they came up 40 years ago, they were absolutely clear to me. And now for some reason they're not.
I know what you're talking about.
Why was it clear to everybody then, and now all of a sudden it ain't clear?
Right.
So that's just part of it. So with that, I guess we will stand adjourned.
Thank you, sir. All right, we're adjourned.